All right, good evening, everyone. Thank you for coming out. My name is Charlotte Rafus, and I am the Executive Editor for State Constitutional Commentary on the Albany Law Review. On behalf of the Albany Law Review, I would like to welcome all of you to the 12th Annual Chief Judge Lawrence H. Cooke State Constitutional Commentary Symposium. Over the years, the Cooke Symposium has provided a forum to discuss the history and background of state courts and judges. We are honored to add to this tradition by having Judge Fahey and our 4 panelists here with us tonight. I would like to introduce our moderator, Albany Law School's own Professor Bonventry, the Justice Robert H. Jackson Distinguished Professor of Law. This symposium would not be possible over the years without Professor Bonventry, who has worked tirelessly to support the Albany Law Review, and we are also lucky to have him as our faculty advisor. I would next like to introduce Dean Wallette. Dean Wallette is the 18th President and Dean of Albany Law School. She is a graduate of Albany Law and was the Editor-in-Chief of the Albany Law Review. We are grateful for her continued contributions to the Albany Law Review, and I am pleased to introduce her to start off tonight's discussion.
Thank you, Charlotte, and welcome to all of you. Tonight should be a very special evening where we have some really good conversation about a very important topic. For those of you who have never been here before, you're sitting in a building built in 1928. This room used to be, for 60 years, it was a 2-story library, so it's been transformed over time. The law school has been teaching law students continuously since 1851, so we've been at this a long time. I want to thank all of our panelists for being here tonight, and I also want to congratulate Charlotte Rafus, who is the executive editor for the State Constitutional Commentary. Charlotte, you've done an extraordinary job putting together a great panel. Can you all join me? So the topic of tonight's symposium is one that I care deeply about, both professionally and personally. I've spent much of my scholarly career exploring how choices in medicine affect our ability to have a good life, what it means to have a good death, and how laws that affect choice in dying affect persons with disabilities. All of those issues are relevant to tonight's discussion. The issues have also affected me on a personal level. 2 years ago, my beloved father-in-law, Pete, ended a losing and painful battle with terminal cancer on his own terms. Pete was a great man, a Harvard-educated physician, and he had the help of another physician in obtaining a lethal cocktail at a time. He was in California at the time, and physician aid in dying was not legal. It was actually legalized by the legislature in California 2 weeks after he died. Pete's experience brought home in a very personal way for our family the issues that we're going to talk about tonight. And they are complex, both legally, ethically, morally, and they're not easy answers, so we're going to talk about them, and I congratulate the Law Review for picking this as a topic. To start our discussion, we have with us a wonderful keynote speaker, the Honorable Eugene M. Fahey. Judge Fahey is an associate judge on New York's Court of Appeals, New York's highest court. Judge Fahey was appointed in 2006 to the Appellate Division, 4th Department by Governor George Pataki, and then he was appointed in 2015, or he was nominated in 2015 to the Court of Appeals by Governor Andrew Cuomo. He was confirmed unanimously by the New York State Senate. When Judge Fahey was appointed to the Court of Appeals, Governor Cuomo predicted that he would be a formidable judge. The governor's prediction was spot on. Judge Fahey is a strong, principled writer and a tough, if sometimes funny, presence on the bench. Appearing before Judge Fahey can be quite a challenge. As a jurist, Judge Fahey is not afraid to stand his ground, Our own Professor Bonaventure has written that Judge Fahey, quote, apparently feels no overriding need to just go along with his colleagues when he thinks they are mistaken. In fact, Bonaventure notes that Judge Fahey has issued over 50 dissents. He often sides with the rights of the accused, except when the accused are officials or people doing harm to children. So interesting observation by Professor Bonaventure. In Myers versus Schneiderman, the case that gave rise to tonight's symposium, Judge Fahey concurred with the court's per curiam opinion, which rejected the plaintiff's argument for right to physician aid in dying, or in the court's words, physician-assisted suicide. I'm going to urge all of you, especially the students, to take note of the use of language tonight. People refer to the practice that we're talking about in different ways. Some people will talk about death with dignity. Some people will talk about physician aid in dying, and some people will talk about physician-assisted suicide. Think about what the words mean and how they're being used and what it means to our arguments. In his concurrence, Judge Fahey expressed concern that permitting the practice, whatever we call it, would place New York on a slippery slope toward legalizing non-voluntary euthanasia, because a right to assisted suicide by the terminally ill in circumscribed last resort situations would inevitably lead to expand to include persons who are not terminally ill. I'm sure that we're about to hear more of the thinking behind these words. And Judge Fahey, we are incredibly honored to have you here tonight at Albany Law School. Will you all join me in welcoming Judge Eugene Strauss?
I have to give not Judge, he wants to be a judge, Professor Bonaventure credit. He does pay attention, and I think sometimes he even gets it right, which is, you got to give him credit for that. This issue, first I want to say that I'm honored to be here this evening. I think being asked to give the opening remarks on the case of Myers v. Schneiderman, which was a 2017 Court of Appeals decision concerning physician-assisted suicide and the statutes under the New York penal law, and whether or not those statutes outlawing that practice are constitutional. I felt that the legal questions in that case were relatively straightforward, but that the moral questions underlying the decisions were both difficult and profound, and that's, of course, why it makes it such a compelling case. Immanuel Kant, I don't get to quote Immanuel Kant very often, but Immanuel Kant said that the difficult decisions are not choosing between what's right and wrong, but choosing between two different rights, what's right on one hand and then what's right on the other hand. And this case, in many ways, embodies a difficult choice between two very arguable rights. And I don't take an absolutist position. And my personal concurrence is really a reflection of my thinking of the historical realities of this decision and the world that we live in. Anyway, let me just talk a little bit about the procedural posture. How did this suit end up in front of the Court of Appeals? A lot of law students, I'm assuming, here, so this is a minor test for you. This suit originated in the plaintiff's request for a declaratory judgment that physicians who apply aid in dying are not violating the state's assisted suicide statutes, which are Penal Law 12030 and 12515 sub 3. The Attorney General moved to dismiss under CPLR 3211A7, which means failure to state a cause of action, and Supreme Court granted that motion to dismiss. The Appellate Division modified but still dismissed, and the Appellate Division modified on the analysis saying that the statutes do not violate the state constitution. Now, as you may know, those of you, particularly students here, the appeal itself generated 4 opinions. A per curiam opinion, which we all agreed with, and then 3 concurrences. Now, a per curiam opinion, per curiam simply means by the court, is an opinion that an appellate court decision makes that does not identify the individual judges who authored the opinion. It need not be unanimous, though it was unanimous in this case. Now, why an opinion was rendered per curiam in any particular case is one of those secrets of appellate practice that judges are bound never to speak of, and really keeps people like Bonaventure in business because they can, and law professors throughout the auditorium in business, really, because they can speculate on why we did what we did. Here, Judges Rivera, Stein, Garcia, Wilson, and myself joined the unanimous per curiam ruling, and then Judges Rivera, Garcia, and myself wrote separate concurring opinions expanding on or parting from the per curiam in certain respects. Two of the judges on the court, Judge DiFiore and Judge Feynman, took no part in the decision. Judge DiFiore had been a Westchester County DA and been involved in a lower court ruling on the case, and Judge Feynman was from the first department where the case came from, so that's why they were recused in those cases. Now, the pure per curiam opinion held that the state constitution does not encompass a broad fundamental right to physicians' assistance in suicide, and that the state's prohibition is rationally related to a number of legitimate government interests. The opinion concluded by noting that the legislature might at some point specify conditions under which it will permit assisted suicide, but the present absolute ban survived constitutional scrutiny. More interestingly, I thought, was Judge Rivera's concurrence, which expressed the view that the assisted suicide prohibition might not survive the rational basis test to the extent it would criminalize the assisted suicide of a person, quoting from the judge, approaching the final stage of a dying process that is agonizingly painful and debilitating. As an example, individuals who are so close to death that they would qualify for terminal or palliative sedation. Judge Rivera suggested that there's no rational distinction in the final stage of a terminal illness between assisted suicide and terminal sedation. Now, Judge Garcia's concurrence, and Judge Stein joined that, responded to Judge Rivera's ruling. Judge Stein, as you may know, is a graduate of Albany Law School, and so is Judge Garcia. Well, Judge Garcia, of course, they're both very bright, very capable, and I think you should be proud of him as an Albany graduate. But Judge Garcia observed that both facial and as-applied challenges to the assisted suicide statute both fail, and that contrary to Judge Rivera, the state's interests are legitimate even when a patient is in the final stage of life. In other words, that the constitutional challenge isn't changed by where what stage in life a person is at, and the state's interests remain the same all the way through. That's what they said. Judge Rivera said it does change, and that was the core of her argument, that the closer you get to death, the state's interests in keeping you alive become diminished. It's a thumbnail version of it, but just to give you a sense of what the dynamic was in the philosophical argument between us. My own concurrence addressed a broader view of the consequences of assisted suicide. I attempted to elaborate on the point that the per curiam decision mentioned in passing, and I'm going to talk a little bit about that. But I want to talk about the complexities of the Meyer case and really begin with terminology, which is something that the dean talked on. In our fevered world of 24-hour news, blogs, and a Twitter universe, terminology becomes all important. And I notice among litigants is that an act that we all agree on what a particular act was is called by different things and labeled in different ways, and that many times in the court, at least personally, I'm only speaking for myself now, not for the court as a whole, I look for labeling particular acts in neutral ways because I don't want the labels that we put on them to be reflective of agreeing with any particular political or policy point of view beyond the decision that we're making. So the terminology does become important in the Myers case, and the terminology is a reflection of the litigants' points of view. The plaintiffs here favor the term aid in dying rather than assisted suicide. And I personally think that to some degree this is because They believe that the word suicide suggests the state of mind of a clinically depressed person who commits suicide as a result of impaired judgment. Plaintiffs argued that this state of mind, that is the reasoning of a mentally competent, terminally ill patient who may wish to bring about his or her death if the patient finds the dying process unbearable, is entirely different from that of a person who ends his or her life irrationally. And the amici New York law professors, led by Professor Bonventuri, took that same position in a very well-written brief, I want to say. Now, this may be more a matter of the connotations of the word suicide rather than its dictionary meaning. And speaking for myself, I use the word physician-assisted suicide. The standard dictionary definition of suicide is, quote, the act or instance of taking one's own life voluntarily and intentionally. That's from Merriam-Webster's dictionary. And it makes no reference to how long the person has to live or whether the self-killing would be regarded as irrational. In other words, I try to restrict myself in our writings to the dictionary definitions as much as possible rather than the cultural connotations of particular words. A second point is more significant. Although the Myers case concerned physician-assisted suicide and not euthanasia, the topic of euthanasia is never far away from the subject of assisted suicide. Of course, there are two legally very different and conceptually distinct concepts we're talking about here. In this country, physician-assisted suicide has been legalized by statute in 5 states: Oregon, Washington, Vermont, California, in Colorado, and the District of Columbia, of course, which is a state, and by a non-constitutional high court decision in the state of Montana. Now, albeit these decisions were limited to mentally competent adult patients who have been diagnosed with a terminal illness that will lead to death within 6 months, euthanasia, by contrast, is illegal in every United States jurisdiction. In euthanasia, a physician brings about the death of a patient motivated by the physician's concern for the patient's suffering or loss of dignity. In physician-assisted suicide, on the other hand, it is the patient who kills himself or herself with the aid of a physician. The common thread, more significant in my view than the conceptual difference, is the use of a lethal dosage of medication intended to end a person's life. Now, in Myers, the issue of euthanasia was pertinent to the question of whether the penal law prohibition of assisted suicide is constitutionally permissible because it's rationally related to a legitimate legislative state interest. The per curiam stated that one such government concern, and one of the reasons that the state has the right to enact this ban, is the government concern to avoid a possible slide towards euthanasia, and this is the subject of my concurrence. It's worth noting, though, some other distinctions, and that's a distinction between what's called voluntary euthanasia and non-voluntary euthanasia. Voluntary euthanasia is euthanasia in accordance with the request of a mentally competent patient. Non-voluntary euthanasia is euthanasia performed on someone else because of a factor such as infancy, mental incompetence, coma, etc. The patient is not able to choose euthanasia and has never recorded a directive expressing his or her will in regard to euthanasia. Now, I want to make clear that in our opinion and in my concurrence, involuntary euthanasia, as opposed to voluntary and non-voluntary euthanasia, was not implicated here, and that would be euthanasia performed on a person who is able to give consent but has not done so, either because the person was not asked or because he or she withheld consent. This third category of euthanasia, performed against a person's will, of course recalls the atrocities carried out against the disabled and physically and mentally impaired by regimes influenced by theories of eugenics. We're not talking about that here, and we're not talking about that in our decision. One of the principal points of my concurrence was to develop the point that the legislature may reasonably criminalize assisted suicide because to permit the practice would be to open the door to both voluntary and non-voluntary euthanasia. To use a familiar metaphor, and the dean referred to it, would place New York on the slippery slope towards legalizing non-voluntary euthanasia. I did not suggest, and I don't suggest today, that it would lead us towards involuntary euthanasia, in other words, towards euthanasia that would be against the express wishes of a patient. Now, as you probably all know, since you probably read up on this a little bit before, internationally, throughout the world, the Netherlands has the longest history of socially accepted euthanasia. And I focused in my concurrence on that jurisdiction. Of course, a court can take notice, judicial notice, of properly cited research and factual findings outside the immediate record of the case, and I would hesitate to do that normally, but in concurrence where you're just writing for yourself, I didn't feel constrained, and it gave me the liberty to talk about those issues on a broader basis as long as they were factually based. In 2002, a termination of life on request and assisted suicide act was enacted in the Netherlands to legalize long-standing informal practices of physician-assisted suicide and voluntary euthanasia in that country. Under that statute, a physician may end the life of a patient who is experiencing unbearable suffering without hope of relief at the patient's explicit request, either by directly administering a lethal dosage of medication by the doctor, which would be euthanasia, or by prescribing a pharmaceutical means of suicide, which would be physician-assisted suicide. By 2015, both euthanasia and physician-assisted suicide accounted for 5,516 reported deaths in the Netherlands, almost 4% of the deaths in that country. The proportion of deaths attributed to euthanasia and physician-assisted suicide had doubled over the 10-year period. In my view, the most striking aspect of the end-of-the-life decision-making in the Netherlands is that there was no legal distinction drawn between physician-assisted suicide, which was the issue before us, and euthanasia. Similarly, physician-assisted suicide and euthanasia were made legal at the same time as one another in both Belgium in 2002, Luxembourg in 2009. Recently, in Canada in 2015, a Supreme Court decision striking down a prohibition on assisted suicide led to a June 2016 law legalizing both physician-assisted suicide and euthanasia in Canada. As I pointed out in my concurrence, quoting now, the movement from allowing physician-assisted suicide to permitting euthanasia is facile. And by that I meant effortless. It apparently has not even been perceived as a transition in some societies outside the United States that have legalized the former practice. One reason for this, I believe, is that the ethical boundary between physician-assisted suicide and euthanasia is very difficult to defend. If a person has a statutory or other right to a doctor helping them commit suicide, does that person lose that right if he or she suddenly becomes too physically weak to self-administer legally prescribed drugs? If not, the line between suicide and euthanasia has been crossed. Indeed, this concern about the transition from physician-assisted suicide to euthanasia was recognized by the United States Supreme Court more than 20 years ago in Washington v. Glucksberg, a decision where the court wrote, quote, "In some instances, the patient may be unable to administer the drugs, and administration by the physician may be the only way the patient may be able to receive them, and that not only physicians but also family members and loved ones will inevitably participate in assisting suicide. Thus, it turns out that what is crouched as a limited right to physician-assisted suicide is likely in effect a much broader license that could prove extremely difficult to police and contain." That's all from Glucksberg. For these reasons, and in light of the practices in the Netherlands, it is certainly reasonable to fear an all but inevitable expansion from a physician-assisted suicide by a patient taking a prescription of fatal drugs to euthanasia by a nurse or physician administering a prescription of fatal drugs. Now, the Netherlands has also displayed another trend that I find disturbing, and that's the countenancing of non-voluntary euthanasia. In my concurrence, I cited a 2005 study showing that 560 people died in the Netherlands as a result of the use of legal drugs not at the explicit request of the patient. The study cited that for every 5 people who died in the Netherlands as a result of euthanasia or physician-assisted suicide, in the immediate wake of the legalization and regulation of the practices, 1 died without explicitly requesting the death. And there was an argument in the study that this was a violation of Dutch law. I'm not an expert on Dutch law, so I can't speak on that, but there was the argument. Such cases involve, for example, patients who were unconscious or mentally incompetent, and it was more common for the euthanasia to be justified by a discussion with the patient's relatives or caregivers than by past discussion with the patient, him or herself. Now, in studying this Dutch modern experience, we're of course not facing government-sanctioned forced or involuntary euthanasia. The decision makers in non-voluntary euthanasia may be very well-meaning, yet neither the sympathetic motive nor consultation with family members renders the euthanasia voluntary. And this brings to my mind the necessity of ensuring the decision-making about prematurely ending the lives of vulnerable, terminally ill people not be entrusted entirely to those who have the financial and emotional burden of caring for them. There is also a reasonable concern that the slippery descent from physician-assisted suicide to non-voluntary euthanasia would be an especial risk in vulnerable and disadvantaged parts of society. This is an issue that we've confronted many times before. In 1994, this issue was being discussed broadly in society and in New York. A New York State Task Force on Life and the Law had been established by Governor Mario Cuomo and commissioned with a broad mandate to recommend public policy at the intersection of medicine, technology, and law. That commission unanimously recommended that New York laws prohibiting assisted suicide and euthanasia should not be changed. The task force reasoned that, and I'm quoting from them, legalizing assisted suicide and euthanasia would pose profound risks to many individuals who are ill and vulnerable. The risk of harm is greatest for many individuals in our society whose autonomy and well-being are already compromised by poverty, lack of access to good medical care, advanced age, or membership in a stigmatized social group. As the task force went on to observe, no matter how carefully any guidelines are framed, assisted suicide and euthanasia will be practiced through the prism of social inequality and bias that characterizes the delivery of services in all segments of our society, including healthcare. The practices will pose the greatest risk to those who are poor, elderly, members of a minority group, or without access to good medical care. It's the end of the quote by the commission. As I see it, those who do not have health care advocates will be most at risk. This has indeed been a concern of medical ethicists for decades. Now, Judge Rivera, in her concurrence, questioned this prediction, noting that research from Oregon shows no heightened risk for the poor, elderly, or the uninsured. My view isn't the same. The experiment with physician-assisted suicide on the West Coast is still relatively young. And the Dutch experience supports the rationality of the fears as to where these decisions can lead us. These concerns are especially compelling given the large proportion of our healthcare resources spent on people that are terminally ill. We spend a lot of money on the terminally ill. To the extent that the funding of medical care for the elderly and infirm becomes limited by economic constraints in the United States, it is not hard to imagine a society in which non-voluntary euthanasia of those whose lives have been adversely affected by such a reduction in care is tacitly accepted. Another community that would be at significant long-term risk is people who are disabled. The court had the benefit of an amicus brief by a number of disability rights centers and associations, and the amici contended that while plaintiffs use the term dignified death to justify assisted suicide, the indignities non-disabled and in some newly disabled people invariably described are the need for assistance in daily activities like bathing, dressing, and the other realities of having a disability. Legalizing assisted suicide enshrines in law the prejudice that death is preferable to receiving the assistance that many disabled people rely on. In other words, for many members of the disabled community who are not terminally ill, the indignities that plaintiffs strive to avoid are suffered on a daily basis. In my concurrence, I made the point that legalizing physician-assisted suicide would convey a societal value judgment that such indignities, as they're called, as physical vulnerability and dependence, deprive human life of intrinsic value. By contrast, quoting now, a disability does not deprive life of integrity or value. There is no lack of nobility or true dignity in being, indignity in being dependent on others. The natural developments of old age and final illness are dependence in waning consciousness. Many disabilities come with similar challenges. It would be a profound mistake to equate limits imposed on a person's life with the conclusion that such a life has no value. On the other hand, Judge Rivera in her concurrence suggested that the concept of dignity was the subject of debate and controversy, and perhaps I think we'll hear more of this from the panelists tonight. I also developed the point in the concurrence that the legislature may reasonably criminalize physician-assisted suicide because a right to assisted suicide by the terminally ill in circumcised last resort situations would inevitably expand to include persons who are not in fact terminally ill. Once again, I looked at the experience of euthanasia in the Netherlands to justify this assertion. Let me give you an example. A person there whose illness is psychiatric, for example, severe depression, may legally receive euthanasia or commit assisted suicide in the Netherlands so long as his or her suffering is considered to be unbearable and without prospect of improvement. Even more disturbingly, the Dutch practice of legalized euthanasia and physician-assisted suicide has been extended to young children. In the Netherlands, children may themselves request euthanasia from the age of 12 and do not require parental consent after they reach the age of 16. Recently, the Dutch Pediatric Association called for the age minimum of 12 years to be eliminated so that each child's ability to ask to die would be evaluated on a case-by-case basis. This would put the Netherlands in line with Belgium, where in 2014, euthanasia and physician-assisted suicide were legalized for children if they met the same conditions as adults, and they possess, quoting now, the capacity of discernment and had parental consent. This expansion of euthanasia is, in my view, an especially disturbing consequence of legalizing physician-assisted suicide. Before I wrap up, it's necessary to, I think, to mention a point of disagreement between Judge Rivera's concurrence on one hand and other opinions in this case on an issue not directly raised by plaintiff's appeal. In speaking about euthanasia in the Netherlands, I've been referring to the act of intervention to bring about a plaintiff's death, or excuse me, a patient's death. There is, of course, another medical practice which ethicists call passive euthanasia, which is now seldom described as euthanasia at all, in which a physician lets a patient die. This essentially passive physician practice occurs when medical personnel remove a patient from a machine that would prolong the life of a patient or withdraw nutrition and hydration from a patient undergoing palliative sedation. It's a common practice, it's ubiquitous, and now generally considered to be unobjectionable, and it is clearly legal in the proper circumstances. The Supreme Court decision verifying that in Cruzan versus the director of the of the Montana Department of Health, which is a 1990 decision. The per curiam decision in Myers, in my concurring opinion, and the opinions of Judges Garcia and Stein all made the point that there is a rational distinction widely recognized and endorsed in the medical profession and in the law between the withdrawal of life-sustaining treatment on the one hand and assisted suicide on the other. We adopted the reasoning of Vaco v. Quill, which case originated in New York, in 1997. The Supreme Court decision upheld the New York prohibition on assisted suicide on a federal constitutional challenge. Our challenge was a state constitutional challenge. Although New York courts can go further than the United States Supreme Court when interpreting our potentially broader state constitutional protections under the Due Process Clause as opposed to the Equal Protection Clause. As the Amici law professors and the New York Civil Liberties Union reminded us that we could do that. We found, however, that the VACO analysis persuasive. In VACO, the Supreme Court reasoned that a physician who withdraws life-sustaining medical treatment may intend, and I'm quoting now from the decision, to cease doing useless and futile things to a patient when the patient no longer stands to benefit from them. The same is true when a doctor provides aggressive palliative care. In some cases, pain-killing drugs may hasten a patient's death, but a physician's purpose and intent are maybe only to ease that patient's pain. A doctor who assists a suicide, however, must necessarily and indubitably intend primarily that the patient be made dead. The law has long used an actor's intent or purpose to distinguish between two acts that may have the same result. Put differently, the law distinguishes actions taken because of a given end from actions taken in spite of their unintended but foreseen consequences. This is a philosophical or ethical principle called the principle of double effect. And basically that means that there is a legally and morally significant difference between performing an action with the intention of bringing about a bad effect and performing the same action without the intention, even though the bad consequence is foreseen. The most common example that occurs is the application of pain-killing drugs, morphine and stuff, in the end stages of life. Although the Court of Appeals as a whole adopted this reasoning, Judge Rivera's concurrence made a pointed, and I want to bring it to you because I think it was well argued, skepticism. She wrote that when a physician removes a patient from a life-sustaining apparatus or declines to administer life-saving procedures, the physician's intent, in accordance with the wishes of the patient, is to precipitate the death of the patient. A physician who complies with the patient's choice to forego life-sustaining treatment knows when a ventilator is withdrawn, for example, the patient will soon die. The drugs involved in terminal sedation are known to cause a patient's death in certain cases. A physician providing this medical option knows very well about the potential immediate consequence and must forewarn the patient. Furthermore, while sedation may be necessary to alleviate a patient's pain, the withdrawal of nourishment, which forms part of the treatment, can only serve to bring about death. I was quoting from Judge Rivera's concurrence there. The analytical difficulties in this area are considerable, and perhaps the panel tonight will touch on those topics, but suffice to say that a clear majority of the court is not ready to depart from federal precedent in this area. I'll end by saying that Myers was among the most interesting and emotionally challenging cases I've heard so far in the court. We had the benefit of excellent briefing and so many amicus briefs, honestly, that my staff had to prepare a chart outlining the interrelated positions. The advocacy on both sides in this case was of the highest quality. We decided here only that the legislature may permissibly ban assisted suicide, not whether it may allow assisted suicide, and I am not sure that I'm sure that the merits of the plaintiff's claims and those of others facing the pain or terminal disease will be debated, particularly in the legislative circles, for many years to come. I just want to close by saying I've been reading lately the essays of an author, Mary Lynn Robinson. She won the Pulitzer Prize a few years ago for a book called Gilead. It's an interesting book anyway, if you ever read it. Anyway, her essays, very intelligent person and very challenging to read, but she was talking about decision-making in an essay about society, and she said the acquisition of wisdom is found through the exercise of humility. Now, when confronting issues like physicians-assisted suicide, I recognize that there are no perfect legal solutions. In other words, everyone isn't going to agree with you. Usually everyone will disagree with you. It's a type of issue that judges would be always wise to consider the consequences of any decision at great length, and most importantly, when making those decisions, to exercise careful restraint. Now, whether you agree or disagree with our decision, I can assure you that in this instance, it was made after long and careful consideration. I want to thank you all for the invitation and for your attention this evening. Take care.
Thank you so much, Judge Fahey. Judge Fahey is definitely one of the reasons why the Court of Appeals is either one of the finest or the finest courts in the country. And when I take my students to the court, they are always impressed with Judge Fahey. They're always impressed with his questions because they're never those kind of nitpicky, fact-based questions as though the court doesn't realize that they're setting precedents and not just deciding a dispute between parties. And neither are his questions overly legalistic as opposed to understanding that the judges on that court are making policy choices. But they're always thoughtful. They always get to the essential nature of the case. And so my students and I have always been very impressed. And as I talk to lawyers around, especially those who are geeks like me and follow the Court of Appeals like a fanatic, they all just love Judge Fahey. They love Judge Fahey. And actually, I asked Judge Fahey recently, I said, were you educated by the Jesuits? Which I thought was a compliment. And he said, no, but by the Christian Brothers, which I think is even better. I've also told Judge Fahey that I disagreed with his concurring opinion, with the result in his concurring opinion. But I was educated by the much inferior Holy Cross Brothers, so I'm probably wrong, Judge. But in any event, again, thank you, Charlotte, for putting this together, our state con editor, and Emma Tyner, our editor-in-chief, and everybody on the Albany Law Review. You know, I get to be standing here because I'm their faculty advisor. It's really a privilege to be the advisor to these students. In fact, I was the faculty advisor when Alicia Willett was the editor-in-chief. And now she's my dean, and let me tell you, she is by far the best dean this school has had in the 100 years I've been here. She really is magnificent. So this is the 12th annual Chief Judge Lawrence Cooke Symposium. He's a 1938 graduate of this school when Chief Judge Cooke was a member of the court without any question. That was the leading progressive court in the country, meaning that with regard to the rights of the accused, free press and free speech, there was nothing in the country like the United States Supreme Court, and we're terribly proud of him. And in fact, he was a founding chair of State Constitutional Commentary, which hosts this symposium. I also want to thank the Sabota family, who have been very, very generous with helping to subsidize the Cooke Symposia throughout the year. Now, I'm not going to recite the bios that are in the programs, but I would like to say a few things about each of our panelists, and we're thrilled to have them. Edward McMahon, he is the Director of Public Policy for the Archdiocese of New York. Before that, he had spent 6 years as an assistant district attorney in Manhattan, 3 years as an assistant U.S. attorney in the Eastern District. He specializes in religious liberty, child protection programs, and Catholic theology. We're really honored to have him here. Then there's Peter Strauss. Among other things, he's a member of the board of directors of End of Life Choices in New York. He's the co-director and founder of Guardianship, the Guardianship Clinic, which he founded in New York Law School. And he's a graduate of NYU Law School. He did his undergraduate work at Bowdoin College, and I understand he was in the ski club and the glee club. And he's promised me he's going to sing part of his presentation. Actually, he never said such a thing, but...
But I could. I would.
But he could, yeah, he could. Apparently, he's famous in Maine. Stephanie Woodward, who's a disability rights lawyer and advocate, and she promotes brightly colored wheelchairs. And on her, it's either your LinkedIn or your Facebook or Twitter, it says she's an all-around mess. Well, I don't know about that, but she earned a law degree and a master's in disability studies at Syracuse University. Several months ago, she participated in a die-in outside Senator Mitch McConnell's office at the United States Capitol. She was protesting proposed cuts in Medicaid, and she was actually forcibly removed from the Capitol. And there are pictures online of you being forcibly removed from the Capitol.
And my wheelchair.
In your wheelchair, yeah. And I think it should be said that a lot of American heroes have been forcibly removed from protest movements. So we're really proud to have you here. David Levin was executive director of the End of Life Choices New York for 14 years. Before that, executive director of Prisoner Legal Services for 20 years. He's a graduate of the University of Rochester and Syracuse Law School. He's an active speaker and writer. And as one commentator I read noted, David has a masterful understanding of the horse trading that is needed when working with the lawmakers in Albany. Horse trading? You mean they don't do everything based on substantive merit, David? I can't imagine that. But those are our four panelists, and we're really thrilled to have them here. So what we're going to do is we're going to allow each of them to speak for 10 minutes, and Charlotte's going to be very, very strict about the 10 minutes so we can get the discussions back and forth among the panelists and then questions and answers. So first up is Stephanie Woodward. Again, we're thrilled to have you here, Stephanie. Stephanie?
There's slides?
Yes, stay here. Yeah.
Oh, no, so thanks for having me. So hopefully I'll get some 5-minute sign. It's been a long time since I've been at moot court, so I'm hoping for the best here. Before I start getting into the disability community's argument again, is it on? Argument on assisted suicide and our opposition, I want you all to just think for a second. If you haven't already thought this or said it out loud, you probably know someone who does. I'm a person in a wheelchair, and at least twice a month, someone will come up to me and say, "You're so brave." And if you're not already thinking it, you know someone who is. And I say, brave for what? For living with your disability. What was my other choice? And they think it's a compliment when they say, well, I could never live like that. And what disabled people hear is, you think that death is a better alternative to living the life that I live. And I think that Judge Fahey really hit upon the fact that our societal values and stereotypes and stigmas about others can impact our views, and we impose our values of life on other people. And I think that's a really important part of our perspective with the disability community. So the disability community, and I say the disability community because every disability rights group that has spoken out on assisted suicide has spoken against assisted suicide. And we've done that because we recognize that the reasons that people are choosing assisted suicide are disability related. And a lot of the discussion is about terminal illness and pain. But what we recognize is that when the studies have been done in Oregon on why people are choosing assisted suicide, the top 5 reasons do not touch upon pain. The top 5 reasons touch upon things that are all disability related, such as perceived loss of autonomy, loss of independence, feeling like a burden on other people, loss of bodily functions such as incontinence. And these are all experiences that disabled people experience every single day. For example, feeling like a burden on others. I used to tell my boyfriend all the time, like, oh, I can't hang this picture, will you please hang it for me? I'm sorry, I can't do it. And one day he finally stopped me and said, Stephanie, if you could hang that picture, you wouldn't. Don't act like it's your disability that's stopping you. You wouldn't hang the picture, and it's okay to ask for help. We live in an interdependent world. We can depend on each other. And disabled people are used to that. We are used to asking for help on others. And our society has determined that that is undignified to depend on others. And that it's okay to want to die based on feeling like a burden on another human being. My great-grandmother turned 101 in January, and her mother lived to be 110. So on her 101st birthday, I said, Mimi, are you going to make it to 110? And she said, I really hope not. And I said, why? And she said, it's too much work for other people. That's where it hit me the most, that feeling like a burden on other people should not be a reason that you choose to die. And it shouldn't be a reason why we choose to legalize death for certain vulnerable populations. So with the disability community, we recognize that our lives have been devalued in society. There's a great political cartoon that shows a person in a wheelchair, and they're in front of the building. The stairs lead to suicide prevention services, and the ramp leads to assisted suicide. And that is the feeling that you get as a person with a terminal diagnosis. You're starting to experience disability. When you say, I want to die, suddenly people say, I understand why. But if any of you in this room said, I want to die, you would receive suicide prevention services. Why are we choosing a select population, a vulnerable population, that would receive suicide assistance when the rest of our world would receive suicide prevention? So our perspective goes to people with disabilities, terminally ill and elderly, because we recognize that we all experience the same disabling conditions, and that those disabling conditions cause us to devalue those particular lives. And we also recognize that in a profit-driven healthcare system, assisted suicide will lead to the more deaths of vulnerable people. So when looking at other states that have legalized assisted suicide, there have been circumstances where people have been denied insurance coverage for life-prolonging treatment and offered instead an option for assisted suicide. Recently, a man named Fabian Stahl wrote an email to the Oregon Health Plan posing a circumstance that if there was a treatment available that would either prolong a terminally ill person's life or turn their terminal condition into a chronic condition instead, but insurance would not cover those treatments, would they be eligible for assisted suicide? The health plan wrote back that yes, that the individuals in those circumstances would be eligible for assisted suicide. So what we're seeing is that as a disabled person, I know how expensive it is to keep disabled people alive. I know how expensive it is just to keep me in society. My wheelchair, I'm sitting on about $8,000, guys. I'm not cheap. To keep someone alive on a ventilator or chemotherapy is expensive. To prescribe one pill that can cause death is cheap. So it would lead insurance companies to choose the cheaper option. And disabled people already know how hard it is just to get the care that we need to live. Instead, we'll be offered the choice to die. And I think what we need to question then is if insurance is denying life-prolonging treatment or treatment that can take a terminal illness and turn it non-terminal, and instead offering you death, is it a choice? Is physician-assisted suicide a choice to die if you're not given a chance to live? So when we're looking at this, we haven't seen any safeguard that has ever been proposed that can prevent people from dying as a result of mistake, coercion, and abuse as well. So we live in a society where elder abuse is on the rise. 1 in 10 elders is experiencing abuse. And this is happening behind closed doors. Of the laws that we have seen, there is nothing that stops a family member that can benefit from the death of their loved one or let's use the word loved one loosely there, from taking them to the doctor, encouraging them to ask for the prescription, picking up the prescription for them, and even being the person to administer that lethal dose. And whether or not that is voluntary is up in the air because it does not require a witness at the time of ingestion. So whether that person wanted to take that lethal dose, we won't know. And in a time where elder abuse is on the rise, that's a serious concern to have. There's also a lot of mistake when we look at diagnoses. As a disabled person, I can't tell you how many times I was supposed to die by now. My mother is probably very disappointed that she had to pay for college because I was supposed to die at 10. She wasn't planning for that. So we have people who will die as a result of misdiagnosis as well. And it's important to recognize that there's nothing to stop doctor shopping as well. So if your doctor that you have been seeing your entire life says, I don't think this is the right choice for you, you can easily go online, find, particularly the Compassion Choices website, which will connect you with a doctor who will. In Oregon, the average time that a person knows their doctor that has prescribed that lethal dose is about 13 weeks. I've dated people for 13 weeks that I wouldn't trust knowing my quality of life and whether I should die. Should your doctor that you've known for, I went to law school, not math school, but I think that's like, 3 months, be able to determine if you should die? So these are the things that, as part of the disability community, we're seeing every day. And it is important to recognize that I would like to highlight what Judge Fahey had said, that we would be codifying into law the fact that our societal value devalues the lives of disabled people and people experiencing disabled conditions. And people who are experiencing terminal illnesses do experience disabling conditions. And so if we codify into law that it is undignified to live this way, what we're saying in our law is that it's undignified to be a person with a disability. And there's already enough abuse happening of disabled and elderly individuals that we don't need to make another legal pathway forward to allow us to die without any sort of prosecution moving forward. So in thinking about this, I want you to think beyond just this idea of excruciating pain, because the top 5 reasons people are choosing this have absolutely nothing to do with pain and everything to do with the lives of the disabled people like me live every single day. Thank you.
Peter,
Am I next?
you gonna sing for us, or?
There has been a little uncertainty about the order, so I thought my colleagues to the right were going to finish up, but this is fine. I'm delighted to be here. This is an exciting and serious and difficult topic, and I respect the views of all of my friends who don't agree with me. There was a time when I was on their side. I had been trustee and vice president of an organization that's long since gone called Choice in Dying. It was the merged organization of the Society for the Right to Die and Concern for Dying. And I had opposed physician aid in dying because I felt we weren't ready for it in this country. I've changed my position, and I want to say at the outset, I think many of the things that you've heard tonight and some of Judge Fahey's comments are changing views, and the fact that the Court of Appeals, I believe, has taken the more traditional position is to be respected. But I think when you look at the fact that we now have 7 jurisdictions that have made physician aid in dying legal, and we have about 32 or 35 legislatures that are discussing legislation, including our own here in New York, I think that there are winds of change, and I think people are going to reevaluate these views. I am a full-time law practitioner. I deal with elder law and trust and estates. I deal with clients in my office or in their homes who are wrestling with these problems, and I can tell you, they don't want to talk very long about the complexities of the estate tax law, if anybody, including the lawyers this month and next, can understand the new laws. They want to talk about their end-of-life choices, and I try to make them avoid this issue by clear expression of their wishes in advance directives, particularly the healthcare proxy and the living will, which I prefer to call a healthcare declaration, but I don't want to divert from tonight's subject. I was one of the authors of the brief in Myers of the National Academy of Elder Law Attorneys. We represented that was the New York chapter of that organization, and Naylor did not take a position on the fundamental issue. Naylor took the position that the court needed to send the case back for a full exploration of all of the issues that you're hearing about tonight. We felt that the factual issues basically should drive the decision in the courts and not have a motion to dismiss, which was granted by relying on old assumptions and old facts. And again, I really found Judge Fahey's presentation tonight fascinating. I think his concurring opinion was very important. I tend to believe more strongly in the views of Judge Rivera, as you can imagine, and I think that you really need to read both, or actually all three, but in particular Judge Fahey and Judge Rivera's concurring opinions. I often say to myself that Judge Rivera's opinion, I don't know why it's just called a concurrence. I think it might have better been called a partial dissent, but that's a matter of language, and I do not understand the complexities of the Court of Appeals, nor the state legislature, by the way. But that's for another day. So let me just touch first on where I fully agree with Judge Fahey. Language is critical. And having said that, Judge Fahey used throughout his remarks the phrase physician-assisted suicide, and you've heard me already say physician aid in dying. So we've made a choice, and I think we really should find some more neutral decision. But I think that's something we need to think about. And I think it does color the discussion, because suicide is a word packed with powerful emotions and raises a lot of anger in all of us. And I just don't think that sets the right tone. Maybe medical aid in dying or physician aid in dying doesn't work well either in your view. But I think we at least have to acknowledge that these are important words. And the other thing I want to say about euthanasia, medical aid in dying is not euthanasia, because it's a voluntary wish on the part of the person. To me, euthanasia, whether we can parse it to voluntary or partially involuntary euthanasia or not, euthanasia is when somebody does something to you. It takes your life without your knowledge and consent. It is a vile, disgusting, awful, scary policy. I abhor what happens in the Netherlands and in Belgium. I think that we only have to look 30 or 40 miles east of the Netherlands to see the Nazi Holocausts and what's going on in other places in the world. And I stand 100% behind Ms. Woodward about this. There's nothing that she said about perhaps some interpretation of the facts that we disagree with in the physician aid in dying movement. Of course there's discrimination against persons with disabilities, but we think it would be disgusting and horrible and tragic if a physician aid in dying statute, such as exists in Oregon and Washington and now California, would be allowed to influence the lives to the point of making people want to die because they have a disability. And we want to reach out to the organizations that represent persons with disabilities to find a bridge, to resolve those issues and make sure that those concerns are not brought into the implementation of the aid in dying statutes. and you continue to make that offer, but I with all due respect, we've really not gotten cooperation. I ran a conference in New York Law School a few years ago on end-of-life choices in a changing political environment, and Ms. Woodward's colleagues from Not Dead Yet came to the second floor. There was a wonderful group of them. Pro sets that they had their signs. I invited them in to hear the debate and participate, have some coffee and muffins. I was graciously declined, and at the outset, they decided not to come in and listen to the debate. And I want to stop that. We do need to work together. What we're asking for here is an understanding that the act of a physician providing terminal medication is not helping someone commit suicide. I heard from David once the story about asking people whether they thought that people in the towers in 9/11 who jumped out of the towers were committing suicide. I've never had a person tell me they thought that was suicide. I think they all agree that that act was choosing the method of their death, which was inevitable, and not being crushed to death in rock piles and steel piles. These are dying people. They have to be certified as having a death likely to occur within 6 months. They go through rigorous evaluation by a psychiatrist and another physician, depending on the state statute. They have to be determined to be free of depression, which is driving the decision to take terminal medication. Obviously, we can't say they're not a little bit depressed. I think we'd all be depressed if we knew we were dying within 6 months. There can be counseling. One way, whether it works or not, that you control the influence of family is that there's no requirement that family be notified. There's a variety of factors here in these statutes to protect against these kinds of things. I don't agree with Judge Fahey's fears about the slippery slope. We can't even pass legislation to allow aid and dying in New York. And the current legislation, which is similar to the bills that were in the hopper the last couple of years, if you sat in at the debates at the Executive Committee of the New York State Bar Association Law section, the Executive Committee won't pass a recommendation to endorse the bill because we've been fighting for 2 years over the details of the credentials of the translators of the people who might be subject to receiving medical aid and dying. We have tough legislatures in this country. I don't agree with many of the state's decisions on issues of concern to Ms. Woodward and myself about benefits and services to the poor, the minorities, the disabled groups. But I can't conceive that this is really on our doorstep within the next 20 or 50 or 100 years, that we're going to adopt actual real euthanasia. It is not within our Constitution. It would violate our rights under the Declaration of Independence and the right to life, liberty, and the pursuit of happiness. I do agree with Judge Rivera when she wrote in her concurring that the state's interest in protecting and promoting life diminish when a mentally competent, terminally ill person approaches the final stages of dying. That the state's interest basically disappears. Now, look at what we do allow. Look at what we do allow. It's legal to withhold treatment from a person. It's legal in all states to allow withdrawal of treatment, knowing that the patient will die because of the removal of a respirator or dialysis. I'm getting the 1 minute signal. Is that 1 or is that 20? We allow terminal sedation. Just think of this. a patient who's suffering, and in this case, probably including pain, and suffering is much broader than pain. We allow a person to be given so much medication, allowed by the Supreme Court under the double effect, that they are unconscious, and we watch the families sit around and watch them die. A week, 2 weeks, 3 weeks, a month perhaps. Now, it's not the family's interests I'm concerned about. It's the rights of the patient. Maybe they participated in that decision. Maybe they signaled it was okay. Maybe they didn't. Look at all the things we allow. What is, from a moral and ethical point of view, the difference between that and a competent person, assuming we provide the proper safeguards, of asking for relief from suffering so they don't have to be terminally sedated until they die? Thank you.
Edward Meckman. Thanks very much. It is an honor to be here. I'm going to start out on a kind of a legalistic point, I suppose, by saying that if this were a trial, I would object to the title of the symposium. And the reason I would object is that it assumes a fact, not an evidence, namely that there's a right to die that we're reconsidering. There is no such right. The Supreme Court of the United States rejected it in the Glucksberg and the Vacco cases. It rejected it in the Cruzan case. Our Court of Appeals has rejected it here in the Myers case. No state high court has adopted any kind of generalized right to die as implicit in a patient's right to decline treatment. And even if any court were to do so, it still does not in any way imply that there's a right to assistance from anyone else. We have to remember, there are two people in the room, right? There are two separate moral actors in the room. There's the patient and this doctor. And we have to make a very careful distinction in the way that we look at those two people. Their intention, their role in the causality of death, right? We do that all the time in the law. All of you have studied tort law, criminal law. We do this all the time. And we have to do that here. I agree 1,000% with Judge Fahey. We have to be very careful about language and what language we use here. Because the terms, they imply things, they shade meanings, they give an impression that they don't otherwise, we don't want them to mean. Let's use the real term. It is suicide when one takes an action to cause one's own death. It has always been understood to be that all the way back to the ancient world. Think of Socrates. The reason we read that dialogue about Socrates' suicide is because everyone understands that's suicide. Our penal law definition is about as clear as it can get. Intentionally aid a person to commit suicide. We didn't have to define the term because everyone knows what it means. The Court of Appeals unanimously understood that the normal meaning of the word suicide is what we're talking about here. The Appellate Division First Department, 4 judges unanimously agreed that what we were talking about here was suicide. The Supreme Court judge who initially heard the case agreed that what we are talking about here is suicide. When the legislature wrote the penal law, whether you accept whatever means of statutory construction you adopt, whether it's original understanding or original public meaning or legislative intent, it's very clear that the legislature intended that what we're talking about here to be suicide, and also that they meant the statutes to reach anyone who assists in doing that, even in the hard cases. Each one of the courts that heard this case cited the drafter's commentary to the New York State Court, penal law. And in that commentary, they stated that the statute, these are the drafters of the statute, stated that the statute would encompass anyone who gave assistance, quote, in the more sympathetic cases, for example, suicide pacts, or assistance rendered at the request of a person tortured by painful disease, and the like. What we're talking about here is assisting another person in suicide. And there are two moral actors in the room. And this is where the distinction between palliative sedation and withholding care versus assisted suicide, this is where it's so important to understand that. Because in each of those cases, the two actors have different intentions, they're involved in different elements of the causation of the death, right? And they have to be treated differently. And even if the individual, the patient, has a right to decline treatment, which they do, that doesn't mean that they have the right to the assistance of anyone else, or that we can basically require doctors or hospitals to give them assistance or refer them to people who will give them assistance, because that's a feature of every statute that's been passed here in the United States and every statute that is under consideration here in the United States, a mandatory referral. Think about it. With the declining of treatment, right? Two people in the room, right? The patient is exercising their right not to have any more treatment, to accept death as inevitable. The doctor's not causing death. The doctor's not intending that person's death. The doctor is acquiescing in a decision by the patient, and in fact, the doctor is legally prohibited from giving treatment that the patient declines. We have two different moral actors, two completely different situations between that and assisted suicide. The same thing with palliative sedation. This is where the person is sedated to a state of unconsciousness so that they don't experience the symptoms and the other clinical symptoms of the terminal disease. They die of the terminal disease. They do not die from the action of the doctor. The doctor's intention is to ease pain, not to kill. The cause of death is the underlying disease, not the sedation. So any attempt to analogize between declining treatment and palliative sedation and assisted suicide falls apart once we realize the significance of the language we use and the significance of there being two actors in the room that we have to take account of their separate intentions and their separate involvement in the line of causation. Okay? Now, Judge Fahey gave an outstanding overview of the slide to euthanasia and the other sort of policy reasons behind the legislature's decision to ban assisted suicide. I want to highlight one of the reasons that the legislature talked about, and I also want to follow up on something that both the judge and Stephanie spoke about. The first thing I want to talk about is the very powerful state interest in preventing suicide. Okay? Suicide is a major public health problem in the United States. It's one of the top 10 causes of death of people in the United States. More people die of suicide than die of homicides or motor vehicle accidents combined. It's gone up 26% in the last decade. We all read about the suicides. We all also know what happens in a school or someplace if there is a suicide. Everybody rushes in to make sure that what happens is not what we know might happen, which is something called suicide contagion. It's a term that's been accepted by the World Health Organization. What it means is that every time there's a suicide, within that person's social group, there's an increased risk of suicide. Every school, right, goes through this. You all know this from being students. We spend massive efforts. Everybody who's driven over a bridge, right, knows the signs that we see. Life is worth living. Here's the phone call to make, right? The state spends a ton of money advertising, paying for counselors, sending people out for crisis prevention. We have suicide hotlines. There's a gigantic social agenda, right, and a legal agenda, and a public policy agenda to prevent suicide. Legalizing suicide for some people would completely undermine that. Because what it would say is that some lives are worth living, but for some, it's okay. Okay? So if we allow some, what's to prevent the contagion then from spreading? Right? It will. It inevitably will. We also have a legal regime here in New York State under the mental hygiene law. It's Article 9. If any of us were to walk over to Albany Medical Center, which I think is right across the street, walk into the emergency room and say, you know what, I'm thinking about killing myself, you know what would happen to us? We will be involuntarily committed for 72 hours for an evaluation by doctors, psychiatrists, social workers, judges, and lawyers might get involved at that point. And in fact, if they find that I'm a continuing risk to myself, I can be involuntarily committed for, I think it's like 6 weeks, to save my life. I have a loved one who attempted suicide at least once and threatened suicide another time, and whose life was saved by an Article 9 involuntary commitment. If we legalize, if everybody's life does not count, then nobody's life counts. If we allow suicides for some, we're telling others that it's okay to do it. The other point I want to make is about the inevitable spread to euthanasia. It's very nice for people to say that we want to incorporate, or they want to incorporate safeguards into statutes. But the reality is, and I respect Peter and David an awful lot. I actually respect very much Catherine Tucker, who was going to be here, except for her plane flight being canceled. Catherine wrote an article. She was one of the principal authors of the main plaintiff's brief in the Myers case. She wrote an online article 2 years ago in a journal called The Jurist, which is published out of the University of Pittsburgh Law School. And she spoke about the legislative protections that we're talking about here. She called them burdens and restrictions. And she specifically opposed any of them. She said that the medical profession should be allowed to self-regulate with no legislative regulations on the practice. And she specifically objected to things like requiring the patient to make multiple requests, including that one of them be in writing. Requiring that the request be witnessed. For goodness sake, we witness healthcare proxies and powers of attorney. We wouldn't witness a request for suicide. Obtaining a second opinion for the diagnosis. Referring the patient for a mental health specialist, which under the bills that are being proposed is just to determine competence. It's not to treat for depression, by the way. There's no mandatory referral for treatment for depression. And mandating a waiting period. Just last month, a law professor from Minnesota, Thaddeus Mason Pope, wrote an article for oncologists entitled Medical Aid in Dying, When Legal Safeguards Become Burdensome Obstacles. And he proposed expanding assisted suicide from adults to mature minors, from people with contemporaneous capacity to people who say it in advance directives. There's your voluntary euthanasia, by the way. From people with terminal illnesses to people whose death is reasonably predictable, which is actually what Stephanie was talking about people who may have a long-standing disease who decline treatment. And from self-ingestion to physician administration. And there we are with the third party, again, that second person in the room having to do this. Europe has gone there. Canada's going there. There's no reason that New York won't. Just because they're having a hard time getting this bill before the legislature is no reason that we're not going to go there. Again, we have to remember the words are important, the two people in the room are important, and we also have to watch out for, not the slippery slope, current events, what's happening in Europe and Canada and elsewhere. Thank you.
David? We stand, they sit.
I try to stand every half hour if I can, so.
Me too.
You got me. How many of you think you're going to die? Anybody? Okay, the only question really is how you're going to die. Who's going to make the decision? And is it going to be a decision that you've made, or is it going to be a decision that the government might make for you? So, for my whole career, I have fought for justice. Professor Von Tu mentioned that I was the executive director of Prisoners' Legal Services for some 20 years, representing prisoners. For 10 years, I worked in legal services for the poor in Rochester, New York. And for the last 16 years, I've been working on behalf of dying patients. And there are justice issues for all these groups of people. And for dying patients, medical aid in dying, or physician aid in dying, is a justice issue. It's extremely important, although there are many other issues which are also important. Life is precious, but it's going to end for all of us. So the only question really is, how is it going to end, and who's going to decide? And are we going to be able to make our own decisions at the end of our lives which comport with our own values and wishes? Aid in dying should be an available option for those who have impending deaths, who have been determined that they are going to die within 6 months. That's the group that we're talking about. We're not talking about people with pre-existing disabilities or anything else like that. We're talking only about people who are going to soon die. And the only question is whether or not those people, and it's a very small number of people who have exercised this right in states where it's legal, about 1 in 300, should those people have the right to get medications if they are determined to be terminally ill and mentally competent. This is a deeply personal right of liberty and autonomy. It is a deeply personal and intimate decision, and there's no credible argument, in my view, for preventing this right when patients make a very thoughtful and considered decision to take medication to end their suffering that they can do in their homes and the time and place of their choosing. Final goodbyes can be said, and the patient can have a peaceful death. It is well documented that aid in dying now takes place across the country. But it is illegal, it is underground, and it's unregulated. So the question really is, should we bring legal aid in dying? Should we make it legal? Should we bring it above ground? And should we make it appropriately regulated? The practice should be legal, and physician and family members should not be at risk of arrest and punishment as they are now. Now, aid in dying really is not suicide. Stark differences exist between those patients who hasten their deaths by aid in dying and those who commit suicide. Suicides are committed by people who have a mental illness who could continue to live but choose not to. It's done in isolation, usually out of desperation, often impulsively and violently, and those deaths are tragic. And we should do everything that we possibly can to prevent those kinds of deaths. To the contrary, aid in dying is available only to terminally ill patients who will soon die. The process usually takes at least several weeks. It occurs always after consultation with physicians and almost always with family members, and it is empowering. The term assisted suicide is rejected by the American Public Health Association, the American Academy of Hospice and Palliative Medicine, the American Medical Women's Association, among others, and in the laws which permit medical aid in dying throughout this country, although there are only 6 of them right now. And just recently, and this brings me to the point that the Court of Appeals was really mistaken when they decided the case on the merits rather than giving plaintiffs the opportunity to develop a factual record and evidence. Just recently, the American Association of Suicidology came out with a position statement that suicide is not the same as physician aid in dying. The American Association of Suicidology recognizes that the practice of physician aid in dying, also called some other things, has been traditionally described as suicide. Although there may be overlap, legal physician-assisted suicide should not be considered to be cases of suicide and are therefore a matter outside the central focus of the American Association of Suicidology. The American Association of Suicidology recognizes that suicides are a tragic event. Our organization works so hard to prevent. This recognition does not assume that there cannot be overlap cases, but only that the two practices can in principle be conceptually distinguished, and the professional obligation of those involved in suicide prevention may differ. And then it gives 15 reasons why these two processes are completely different from each other, and at the end of this paper, which just came out at the end of last year, it says, the American Association of Suicidology is dedicated to preventing suicide, but this has no bearing on the reflective, anticipated death a physician may legally help a dying patient facilitate, whether called physician-assisted suicide, etc. It constitutes a critical reason why these distinct death categories are so often conflated and should be deleted from use. Such deaths should not be considered to be cases of suicide, and are therefore a matter outside the central focus of the AAS. There is no definition of suicide in our penal law. There is a prevention of assisted suicide, but certainly, even though when the law was passed, there was a concern about people helping other people who were terminally ill and maybe in great pain, that did not contemplate doctors because the laws were passed before medical aid in dying was legalized in Oregon, Washington, and other states. Now consider, we've had an experience in those states for 20 years in Oregon, almost 10 years in Washington, and now several years in other states. There is absolutely no evidence of disproportionate impact on vulnerable populations, none. Nor is there any evidence of coercion or abuse. In fact, the executive director of Disability Rights Oregon, the Advocacy and Protection Agency in Oregon, said that he's not received one complaint of abuse or coercion in Oregon with the death with dignity law in that state in 20 years. There is evidence, according to one study, that family members of those who request aid in dying feel better prepared and accepting of death, and there are no negative effects. About 90% of those who end their lives by aid in dying are actually receiving hospice care, the gold standard of end-of-life care. But still, their suffering is so great that they feel that they can no longer go on living. These are not people who want to die. They want to live, but in fact they are dying, and the only question is, how are they going to die? There is no evidence in this country of any slippery slope, even though we've had a law in Oregon for 20 years, Washington 10 years. In fact, as Peter mentioned, it is very difficult to get aid in dying laws enacted, which is why we only have 6 states and the District of Columbia which have now permit aid in dying, aside from the state of Montana. And so I think that the slippery slope argument really is not a very valid one, because there simply isn't evidence. Our culture and our experience in this country is so much different than the Netherlands and other countries. There is no reason to think that in the near future or in the distant future that we're going to allow anybody but people who are terminally ill to consume self-consuming medications to achieve a peaceful death for themselves. You know, in Washington, there's a comprehensive regional cancer center in Seattle. It implemented a program for patients who might want aid in dying. Why? Because it realized that this was an appropriate choice, an appropriate option for some people. And what it said was, overall, our Death with Dignity program has been well accepted by patients and clinicians. In New York, 77% of the public, according to a 2015 poll, supports aid in dying. Physicians support aid in dying, according to a Medscape poll in 2016, by a 57 to 29% margin, almost 2 to 1. And there is a groundswell of medical associations now taking neutral positions that had once opposed medical aid in dying. Why? And about 10 just in the past couple of years. Why? Because medical aid in dying has worked as intended in the states where it's been legalized. It is clear that hospice isn't enough for everybody. The executive director of the Oregon Hospice Association for 15 years was opposed to aid in dying when it was first implemented in Oregon. But what she said was, I was arrogant. And I realized that there are people who are suffering so much that aid in dying is an appropriate option for those people. And then she said, while some healthcare professionals expressed fierce opposition to medical aid in dying prior to the law changing in Oregon, since then, those voices have softened in the face of indisputable evidence, and no representative medical organization has called for the law to be repealed. There is simply no evidence of any problems that emerge, except on rare occasions, as Stephanie pointed out, there are mistakes that are going to be made because no law works perfectly. But the aid in dying laws that have been enacted in the United States have worked about as well as any laws can work. Thank you very much.
Thank you, David. Now maybe we can engage in some immediate give and take. And Judge, can I move your chair up here?
Why you guys put me on this side?
Come on over here.
You were a brief on that. So let me start off. Yeah, terms are important, and it should be stated that depending upon which side they're on, there are objections to whether we're talking about aid in dying, right to die, and there are objections to assisted suicide. Some pretty strong objections to both terms, depending upon what side of the argument you're on. But let me ask you a question that's a little more basic, a little more simple, and that is, it seems like there is an assumption that everyone is making, that there is something wrong with suicide, with taking one's life. Is that neutral enough, taking one's life? There's something wrong with that. Is that simply is it a cultural and religious construct, or is there something inherently wrong with a mentally competent adult choosing to take that adult's own life? Is there something inherently wrong with that? Because whether we're talking about, no, it should be barred, or whether we're talking about, well, it should be very limited, we all seem to be assuming that there's something wrong with it. Am I mistaken what everybody is assuming? Who wants a shot at that one?
This is dangerous. I'd like to point out that it's wrong in that it's a choice that can't be taken back. So Michael Phelps, we all know him, he likes to swim a lot. He went through significant depression recently and had suicide attempts and got counseling. And when he got out of that, he said, I am so glad I got help. I'm so glad I'm still alive. If it wasn't for that, that's not a choice that he can take back. So in its permanence, it is wrong, because given that help that you could need, you could change your mind, and you don't have the opportunity to do that if you're in a casket.
Anyone?
I think also
I'm not so sure that Vince, that the question is really relevant here. It is a philosophical, a theological issue. There's a societal norm in it. I mean, I just assume suicide is not a good thing. We need to help people to prevent it, whether it's because society is pressuring them because they have a disability and they feel isolated and wronged. These are terrible causes of suicide. I don't. This is not a subject of theology, and I'm not a theologian, but some of our religious groups say only God can take your life, and I think that's a fundamental part of the societal view about suicide. There's a story in Judaism. I can't speak for Catholicism, but I know in Judaism, you're not supposed to, in theory, this has changed in the Reform movement, but not necessarily in the Orthodox Jewish movement, that withdrawal of treatment, withholding of treatment is wrong, because only God can take a life, and it is only at the very few moments before death that you could assist someone in dying. And that's the Orthodox view. But there's an old rabbinic story about this great rabbi who was dying for years, and there were 30 rabbis on the street below his mud hut, and they were praying for him to live. And his servant person felt he should be let go, and she went up to the roof and she pushed this earthen vase off of the roof. It fell to the ground. It caused a loud noise. The rabbis were startled and stopped praying, and the great rabbi died. And that story is viewed with great reverence, even in Orthodox tradition. So there's no right or wrong on this, but it is an issue. But again, we come back to the starting point here. If this is not suicide, then the assisted suicide law should not be applied and cannot be applied. So fundamentally, how we view this is critical, and that's why our brief from the National Academy of Elder Attorneys asked the court to look at this rather than relying on old dictionary definitions of what suicide is. That we need philosophers and theologians and lawyers and doctors and family members and persons with disabilities to come before a judge at a trial and parse out whether these views, based on old laws and old definitions, really fit in terms of society's attitude towards life and death.
Thank you. Judge, did you want to weigh in?
Well, I'm not speaking as a judge, and so I'm not giving you my legal opinion. But the short answer to the question is yes, I think it's wrong. I think suicide is wrong. I think it's a denial of life, and it's an act of despair. And so I would always think it's wrong. That is not the same as making a decision as to whether or not someone should have assistance in terminating their life. That's a legal question, and I think it's more subtle and more complicated than that. But I think that as I do start from a moral place where I believe suicide is wrong, and I wouldn't want you to think anything different. That doesn't determine my decision, but I think that philosophical position is also reflected in our law, and pretty much throughout Anglo-American jurisprudence, and frankly, throughout the Judeo-Christian ethic, extending almost 2,500 years. So it has a sound foundation in the fundamentals of our jurisprudence. But yeah, I do think it's wrong. There's a, talking about books a lot tonight here, there's a book written by a guy named Walker Percy. It's called The Thanatos Syndrome. I don't know if you ever had a chance to read it. But it talks about, it's a speculation about a near future where a culture of death has taken over versus a culture of life. And these are very emotional and highly toxic topics to talk about. So I want to say I really respect the way you've all acted tonight about these very, very difficult topics to talk about, because almost all of us have someone we know who's gone through a difficult experience, and it's almost difficult to tolerate and even talk about them sometimes. But anyway, if you get a chance, read the book. I think it's worthwhile to get a perspective. But the short answer to your question is yes, I do think it's wrong. And no, I don't think it's a choice you should be able to make.
Thank you, Judge. David?
A little bit on a tangent, I think, but still, doctors help their patients die all the time. And patients are ready to die. They're on a life-sustaining treatment, a ventilator, a feeding tube. The doctor acts to remove that at the request of the patient who is now prepared to die. The patient may not even be terminally ill, and they have that absolute right to have this happen, which will cause their death. So we know what the result is going to be, we know what the intent of the patient is going to be, and the doctor assists them to make that happen. We, of course, don't call that assisted suicide. The patient is no different than the patient who wants to die by some other option, namely by medical aid in dying. And in fact, when the doctor participates in withdrawing life-sustaining treatments, such as a ventilator or a feeding tube, that doctor is much more actively involved in the resulting death than when the doctor simply prescribes life-ending medications for the patient, which the patient may or may not take. And about 1/3 of patients, in fact, never take those medications to end their lives. And we don't know what the intent of the doctor really is in any situation. The doctor may not want his patient to die who has to have the ventilator withdrawn, but he's doing that, or she's doing that, because that's what the patient wants, and the doctor is simply carrying out the lawful wishes of the patient. The same is true of medical aid in dying. The doctor may or may not intend that the patient actually take the medications. We don't know what the intent of the doctor is. So I think these are all important points when we consider this in context of what is going on when people are near or at the end of their lives. And again, remember, people can end their lives very prematurely by having life-sustaining treatment withdrawn, even though they are not terminally ill.
Thank you.
I'll just add that I think it's very facile, to use the judge's word, to dismiss the entirety of the immemorial tradition of, again, the Anglo-American legal system and the Judeo-Christian ethic against suicide. It is very clear that there has been just this long-standing, traditional understanding of that. And I think it's Chesterton who said that there's the democracy of the dead. And I think we have to respect these traditions, long-standing moral judgments. I think even though if we transcend from that and even don't even talk about theology, if we look at what the biologists will say, they say that self-preservation is one of the fundamental motivations of any living being. And if you look even at what the anthropologists say is the hierarchy of needs, at the bottom of that pyramid is life, preserving life. So I think that it's a very deeply ingrained notion in human nature, I think also in our legal and social tradition, that suicide is wrong, that we have a duty to preserve our lives and we have a duty to preserve the lives of others.
Does somebody have a question? Go ahead. Excuse me, sir, can I get you to speak up because in the back, yeah.
I think you have to distinguish between ordinary medical care and extraordinary medical care. The life support systems in that are extraordinary needs. That's totally different. Totally different than suicide, you know? And I think people would, decide to take the not to go that far, okay, depending on their circumstances. Maybe they have a case of cancer, and 6 months, by the way, is kind of a number that seems to pop up all the time. My father-in-law was told that he was going to die in 6 months, and then he got a second opinion from Dana Farber in Boston, and it turns out he enjoyed his great-grandchildren for an extra 6 months and died in the presence of his family, which was, there's a lot of stories where people have decided not to end their life or consider that. The other thing, I was at a medical lecture once where the psychiatrist was presenting, and he said, "You guys know that it's against the law." Now, I have a lot of eminent lawyers here that can tell me if it's a moot point because it's how you arrest a dead person. But the fact of the matter is, it is illegal. That was the point that he was making. And so, I was thinking about the American Society of Suicidology, I think you pointed out. Is that a board-certified medical specialty? Because I know a lot of medical specialties that you have to take boards and be certified, and I don't know if that's a legitimate
Field of medicine. You want to take that one on? Suicidology?
Or do we just make that up?
Let me bring it back to, from philosophy to just law in a free society. A law in a free society. And I'm trying not to take sides, although you know what my side is. And I should not take credit for that brief. The judge keeps giving me credit.
I thought you wrote it.
Because it was brilliant or it was not that good?
It's okay, but I'm just telling you.
It was just that the names were in alphabetical order, so my name happened to come first, yeah. Like in a free society, we repeatedly reject notions that have been held dear for a long, long time. And even just in the past few decades, we have seen that there are notions of Judeo-Christian morality or other cultural beliefs that we've had, and we've now rejected them. So I think there are some people who would say, well, the fact that this has been a belief for a long time isn't necessarily a particularly strong argument. So again, instead of philosophically, in a free society, again, is suicide something against which the government does have a legitimate interest in and of itself in preventing, or is it the risks? Is it the possible slippery slope? Is it that we're not going to be able to limit it to people who actually are competent at the time they make the choice? I mean, is that what's wrong with suicide in a free society, that there are all these risks and possibilities? Or is there something in a free society where we could say government actually does have some interest in telling an individual adult you can't do it? I am just opening that up, as somebody who was not educated by Christian brothers.
My response would be to look at Judge Rivera's concurrence. She does not say that it's wrong to enforce a state interest in preserving life up to a point. But she says at some point where death is inevitable, it's going to happen soon, we can't stop it, people are suffering, that the state interest is not the same. What is the interest of a state to prolong suffering if it's factually happening? And I think that's the answer to your question. We're not saying that the state has no interest in preserving life. Of course we do. Just as the state has an interest in protecting the rights of persons with disabilities and the poor and the uneducated and providing health care, which we don't do, of quality throughout the country. Those are state interests, notwithstanding what some sections of government may be saying these days, but I don't want to get political. But I think that's the answer to the problem. There is a right, but it diminishes under appropriate circumstances.
Anyone want to add to that? David?
Okay, I'll just say I think that we all understand that the law has an enormous teaching value, and I don't think that it's any one of those factors. I think it's all of those factors. I think there is a general social interest in preserving life, but I think that a free society doesn't transcend from morality or tradition. I think those are important factors, since every law is a moral judgment. But I think that we have to really look at what is the law saying if we say that it's all right for some people to take their own lives. And I think this goes back to the very important point I think that Stephanie made before, that since the primary reasons that people give for making this decision of assisted suicide have to do with living as a disabled person, they're getting the message. And that's not a good message for us to be sending.
But the use of the term protecting tradition is very scary to me. We no longer protect the tradition of barring interracial marriage. We no longer protect the tradition of hanging blacks in the South. We no longer protect the tradition of prohibiting gay marriage. We've come a long way under the Supreme Court cases. And remember, in the two cases in 1997, 97, that Catherine Tucker argued before the Supreme Court, the court said, the court was very kind to the plaintiffs in those cases. It didn't say you're terrible people who want to off people for no reason. The court said this is an important debate which should be repeatedly discussed throughout the nation, and under different circumstances and different times, we might reach a different conclusion.
David?
Well, the Court of Appeals, although it was early in the debate about same-sex marriage, our Court of Appeals made a wrong ruling in Hernandez versus Robles. On the other hand, it's made correct rulings and looking forward instead of in Myers, where I think it looked backwards. In the consumer area, and Sherrick against Buick, in the prisoners' rights area, and Cooper against Moran, they were forward-looking, the Court of Appeals. It's unfortunately, in this case, they look backward, and what they should have done, in my opinion, the judges of the court, respectfully, should have looked at the Second Circuit decision on which held in Quill against Vacco, the writing of a prescription to hasten death involves a far less active role for the physician than is required to bring about death through asphyxiation, starvation, and or dehydration. Withdrawal of life support requires physicians or those acting at their direction physically to remove equipment, and often to administer palliative drugs which may themselves contribute to death. It simply cannot be said that those mentally competent terminally ill persons who seek to hasten death but whose treatment does not include life support are treated equally. And then the court asks what I think is probably the most important question, which really we need to think about, and that is, what interest can the state possibly have in requiring the prolongation of a life that has all but ended? The state's interest clearly diminishes, and diminishes a great deal to the extent that they don't have a valid interest in preserving a life which is virtually over with in any event, when the patient decides for him or herself that it is time for him or her to go, even though they would like to keep on living, but they are in fact dying.
Stephanie, did you want to speak?
A lot has happened since I was going to talk. So I think that we really need to recognize that we're not just talking about lives that have all but ended. When we're talking about terminal, we're talking about people with 6 months left to live, and that is with or without treatment. So when we're thinking about terminal illness, are you thinking about your run-of-the-mill diabetic who can choose to forego their diabetes treatment, who would then be considered eligible for assisted suicide? Are you thinking about me? I am an average, healthy 29-year-old girl. I own a house, 4 cats, living it up over here. I get kidney infections regularly. Should I choose to forego kidney infection treatment, I will undoubtedly be terminal within 6 months. We're not talking about people who have all but ended their life. We're talking about people who could just choose to end their life based on their circumstance. If my boyfriend breaks up with me, I could become depressed, decide I don't want to live anymore, and all I have to do is stop taking kidney medication to become eligible for assisted suicide. So you have to think beyond your stereotype that's in your mind of what has been shown to you on social media of the sad person who is just on the edge of death. There are more people at risk here, and I think our country's interest in this is not in upholding tradition, although I am so happy that our courts haven't upheld traditions of continuing harm against vulnerable populations. This will perpetuate harm on vulnerable populations. Allowing suicide to all would eventually only impact the most vulnerable, because people who have access to services wouldn't have reason to want to die. People who are living in the worst circumstances would.
With regard to what Stephanie was speaking about, let me just relay the story briefly. When I was at Union College, we had a geneticist who was teaching one of our biology courses, and he was advocating that parents who knew that their child yet to be born was going to have a physical impairment had a moral obligation to abort that unborn child for any physical impairment. And I have to say that Tony Corpinello, former appellate division judge, was one of the few students in that class who protested mightily what that geneticist was saying. So there are people with some very, very different views than I think that any of them we've been hearing here. But we have a question in the audience. Go ahead, sir.
If New York enacts the medical aid and dying law along the lines of Oregon, California, can that right be taken away by the courts? In other words, could the statute immediately be challenged on some kind of constitutional grounds and the courts would override the legislature?
Because the case could appear in front of me, but could there be a challenge? Yes. And sure, you could challenge anything. Any law that's passed, you could challenge. I have no idea what would happen. I honestly don't, and I couldn't give you an opinion even if I had one.
Do we have anything from California or Oregon that would challenge the existing statute?
all challenges that have been made in the past have failed. Because the Supreme Court of the United States held that while there is no constitutional right to aid in dying under either the Equal Protection or Due Process Clauses of the federal Constitution, that this is an issue which is to be left to the laboratory of the states. And that's why some states have legalized medical aid in dying, and any challenges that have been made, and there have been a few, have been unsuccessful.
Emma?
Between voluntary euthanasia and physician-assisted suicide / aid in dying, if you have an individual who otherwise meets all criteria, including a terminal diagnosis of 6 months, but they are not able to self-administer, wouldn't there be an immediate equal protection requirement that those people also had to have access to a right in dying if it were enshrined in state constitutional protection? And how does that affect sort of your attestation that we would never reach voluntary euthanasia being legalized in this country?
I'm not a constitutional expert, but it would seem to me that the requirement that you have to be able to self-administer would not violate the equal protection rules based on the way the courts have looked at this. But again, this is not my area. But there are lots of discrimination in the existing statutes that might trouble a lot of people. This hasn't come up tonight, but I point out to my students, because I also teach a course called Aging in America and Elder Law, as well as running the guardianship clinic. And we talk about the fact that the 6-month rule means that people who are not dying can't avail themselves of aid in dying. If you have Alzheimer's disease, but still have some capacity to make rational judgments, you're level 4 out of 7 perhaps, and you don't want to suffer the final stages in 5, 6, and 7 really in a terrible state, you can't avail yourself of aid in dying because you don't meet the 6-month test. And there are people who feel that's wrong, and there have been clamors to expand the rules, and I think Judge Fahey referred to this earlier. That I wouldn't call that a slippery slope, but that would be an expansion, which at the moment I'm not prepared to accept because I think it could lead to potential abuse. So I think so far these rules have worked. I don't think 20 years is enough to start eliminating some of the restrictions. I do want to say that the comments about Catherine Tucker's calls for elimination of some of the requirements is somewhat taken out of context, because Catherine is making those arguments in the context of saying aid in dying should be a medical decision, not a legal one. It should be discussed and decided in the context of the patient-physician relationship. And it should be based on issues of standard of care and whether aid in dying would meet appropriately adopted medical determinations of what's an appropriate standard of care, rather than having this list of statutory restrictions. I don't have an opinion on that, but I think that when we quote Catherine's statement that we should eliminate all these rules and reporting requirements, she believes that it should be brought into the same way we deal with withdrawal of treatment, withholding of treatment, and voluntarily stopping eating and drinking, which is legal. You can end your life by stopping eating and drinking, and that's a common practice now and a growing one in this country. So I think we have to look at these restrictions in the context of how we want to view these decisions, and I agree that it really should be confined to the medical decision-making between patient and physician.
Yeah. Edward? I actually think that's exactly how the Medical Aid in Dying Act, if it were enacted as proposed, would be expanded, and all the legislative barriers or protections would be eliminated. You know, we're lawyers. What we learn to do is we learn to define things and then stretch the definition, right? And then try to fit other things into the definition and then come up with a new definition, right? All these rules will be evaluated by courts based on, if it's an equal protection challenge, based on a rational basis standard. So if a judge thinks that there's no rational basis to distinguish between a 19-year-old and a mature 17-year-old, the law goes. That limit goes. If a judge thinks that it's irrational to say 6 months as opposed to 12 months, that goes. If a judge thinks that it's irrational to distinguish between a terminal diagnosis and unbearable suffering of some other kind, that goes also. So that's the way the equal protection argument, I mean, we've seen this in other areas as well, right, throughout the law. The equal protection argument is used as a wedge to expand legal rights and protections. And that's exactly, I'm absolutely convinced that's exactly what would happen here.
But the whole slippery slope argument is I think, from people who have such a narrow view of the trustworthiness of Americans. Now, I'm not saying we're all perfect, but we don't allow physicians to be unfettered in their decision making, and this is true in the issues of mentally ill. In Article 9, we do have rules about the time limits for involuntary commitment for psychiatric reasons, and we don't leave it up to total standard of care. You have to get someone to approve a decision to go beyond commitment for certain time periods, even though the doctor feels that it might be appropriate.
If I may jump in just really quickly on a separate note, to answer, gentlemen, your question, well, not in the U.S., just this week in Canada, a man with a terminal illness is suing the Canadian government for offering assisted suicide without guaranteeing Canadians will receive proper care if they want to live, because he was denied coverage for his treatment to prolong his life, but was offered assisted suicide. So while not U.S. courts, sometimes we listen to our neighbors occasionally, depending on who you are in the country, so it could impact us in the U.S. as well. No, it's just a claim right now, but hopefully we'll see how that goes.
Gentleman up here?
Yes, thank you. So first off, fantastic discussion. I appreciate the opportunity to hear both sides of the argument. Very good. Thank you. Ms. Woodward, at the beginning of the conversation, you started off by saying that the elimination of suffering was not one of the top 5 reasons for assisted suicide or medical aid in dying. Mr. Strauss and Mr. Levin both said there's no evidence of abuse, and further stated that our culture is so much different than that of the Netherlands that we ought to dismiss the observations and the findings of that practice. So perhaps you can elaborate on the cultural differences between the Netherlands and the U.S. to allow us to dismiss those rules or those observations. And also, maybe you can just kind of help us understand what seems to be a disconnect. Ms. Woodward, you're saying one thing about the absence of pain and suffering, whereas Mr. Strauss, Mr. Levin, your argument has been completely on the elimination of pain and suffering.
Go ahead, Dave.
Stephanie is right that pain is not one of the top 4 or 5 reasons why people, at least initially, opt for seeking medical aid in dying. But suffering is always an issue for people. Intolerable suffering from whatever their circumstances are, which they define. Stephanie may define suffering in one way, and another person who is dying and terminally ill may define suffering in another way for him or herself. So it's about the quality of life for that particular person who is dying, who must decide for him or herself as to how much suffering he or she can endure.
So being a burden could be defined as a means of suffering.
It could potentially be at the time when the person is likely to die within, generally speaking, weeks or so, at the time that they do have a terminal illness. So they can decide for themselves what constitutes good quality of life, what constitutes suffering for them. And that's what we're talking about here, as long as they're mentally competent. And in the states which have legalized medical aid in dying, there have to be 2 different doctors who make a determination that the person is not only terminally ill, but is also mentally competent. And if either one of them thinks that the person is suffering from a psychiatric or psychological illness, then that person has to be referred for counseling before they would be given a prescription for the drugs.
I think it's important to note, I'll do this very quickly, that in the statutes where they exist in the 6 states, pain is not a factor for eligibility. It is just not in the statute.
So it's just the suffering is what's in the statute.
I don't even think it says, it mentions suffering. It's the death, et cetera, the capacity, the counseling, things like that.
Yeah, and one thing I can tell you is the process usually takes about an average of 7 weeks. So this is not something which people are doing on the spur of the moment or thinking, well, it's time for me to die because I now have a terminal illness. I've been given 6 months or less to live. These are people who think about this a lot. In fact, about 1 out of every 6 people thinks about the possibility of medical aid in dying. About 1 in 50 talks with their doctor about it, but only 1 in 300, far less than 1%, actually end up taking the medications.
Prescriptions, I think you should.
Yeah, about 1,500 prescriptions in Oregon. So we know that it's sparingly used, and that's a good thing. And that shows that the law is worked as intended. It only applies to people who feel that they are suffering to such a great extent that they can no longer go on living as much as they would like to do so.
I would like to point out that in recent years, only 4% of people who requested assisted suicide in Oregon were referred for a psychological evaluation. So to say that a doctor would know if you're depressed, I'd like to just throw out there that a lot of you are law students. If you go to the doctor, your doctor might not see that you're depressed, but I know that you are. In fact, studies do show that after graduating law school, people come out with depression from graduating law school. So your primary medical physician is not going to see your depression. And I would like to point out that it is harmful for me as a disabled person to hear that living in the way that I live is considered knowing suffering to others, and that instead of getting those other people who view my life as suffering and living my life as suffering help and getting them suicide prevention services that any other person would receive, we would accept that their view of my life as suffering is a good reason to want to die. Like, I'm going to be honest, it's incredibly offensive to me, and it's not lost on me that I'm filled in a room full of people who may not understand that perspective because you all walked up steps to get in here. But I hope that you'll consider that when you're considering what you think is suffering, because disabled people aren't suffering. That transition can feel very scary, but that doesn't mean it's suffering.
Yes.
But isn't the issue not how I perceive you, but how you perceive you?
Right, and when the world tells you there's something wrong with you every single day, you start to believe it. So you could give a person suicide prevention services to help them see a different view of themselves, just as you would a non-disabled person if they wanted to kill themselves.
Sure.
So a primary, moral idea in, I guess, society and in the medical community to mitigate harm and suffering. So for both sides, how would you argue, A, how the mitigation of, pain in some person, the allowing of suffering for someone who is dying, say, within the next 6 months, is somehow a better idea socially compared to allowing them to end their suffering? And then B, how would you argue that somehow allowing someone to end their life is then a benefit to society?
I'll start off a little bit on that. Being very sensitive to what Stephanie said about the notion of suffering. Suffering is a reality of everyone's life throughout our lives, and it is a very subjective thing. But what the challenge is, I think in any case, but particularly when a person has an illness, is to deal with the multi-layered suffering that they may be going through, and to help them to live. We keep on saying the person is dying, the person is dying, the person is dying. The person is alive, right? They're living. So we have to help them to live while they're alive. And to do that, maybe we have to alleviate their pain. Maybe we have to alleviate their psychological suffering because they're depressed or anxious or whatever. Maybe we have to help them alleviate their family suffering. Maybe there's been divisions in their family that we need to help them to reconcile or heal. Maybe there's spiritual suffering, which many people have, and they need spiritual help. That's why there are chaplains in every hospital. So I think that we get lost, I think, when we focus too much on suffering and when we focus too much on dying. The person who's terminally ill is living. And I think the focus should be then on by society as a whole is to help that person live better. Maybe that's an answer to what Stephanie's saying about how demeaning it is to her to hear that people think she's suffering. No, she's alive. She's really alive. And we need to help her to live better and to be happy with her life. Same thing with a person with a terminal illness. So I think that's the overall sort of ideology, I guess, maybe that I would be approaching this with, not focusing on the negative, but to help the person experience their life positively.
And we do have solutions for your question. Since the Supreme Court cases in 1997, the growth of palliative care has been remarkable. It's now in existence in every hospital in the country, whereas formerly it was poo-pooed by the general medical profession. And hospice has grown dramatically. And that is an alternative to aid in dying. People go into hospice, and as David pointed out earlier, a large percentage of people who do aid in dying are already in hospice, but that isn't satisfying their need to be relieved of whatever you want to call it, suffering or pain or whatever. So we do have an expanding world of palliative care and hospice, which should be supported, and I think we're on the same side here. We all support that. But also, if people don't want to go into hospice, they want to go home, they need home care aids, and poor people can't afford that. And only New York provides a home care program under the Medicaid system. Other states don't have that. Medicare doesn't cover long-term custodial care. Hospice at home gives you a few hours of aids a week, but we need more of that, and we can't just cut budgets and cut back on Medicare and Medicaid programs, which offer people options to some of these more perhaps called radical solutions because they don't have alternatives.
If I may just quickly, that is an argument that we've heard before. The founder of Hemlock Society said that people in nursing facilities say that they would rather die than be there, so why don't we give them what they want and let them die? For me, the solution is not to let them die, it's to provide the resources to live at home. So when you say that people want to be at home and they need home care, but poor people can't afford that, to me the solution is not so let them die. The solution is to fix our system to help people live. And we can't have a system that gives people a choice to die when we don't give them the choice to live.
We totally agree. We're on the same team here.
Yeah.
So, David?
I agree with all three of you. An assessment should always be done to see what we can possibly do for the patient so that the patient might not want to die, if there is a way of improving that patient's quality of life. But that's also true of the patient who says, I want to have my ventilator withdrawn. We should treat all patients the same. There really isn't any difference. We're talking about patients who say they're ready to die. Maybe they really are, maybe they're not. Maybe we can deal with some of the spiritual or psychosocial or anxiety or pain or other issues that they're suffering from, and so they won't want to have that respirator, ventilator withdrawn, that feeding tube withdrawn, or they may not want a medical aid in dying if it were legal. But we should treat all patients the same way. It doesn't matter whether they're seeking to have life-sustaining treatment withdrawn, or if they're seeking possibly medical aid in dying.
If we should treat all patients the same way, does it matter if they're terminal then? Why wouldn't we allow everyone access to assisted suicide?
Well, we do allow people who are not terminal to have their life-sustaining treatment withdrawn. So anybody who is, for example, on dialysis, even if they're 30 years old, could say at any point in time, I do not want to continue to receive dialysis because I have to receive this every day, 24 hours a day, and I cannot, for me, my quality of life has been so diminished that I'm suffering to such a great extent that I want to have to stop dialysis, and that patient has an absolute right to stop the dialysis, and the result is going to be death.
Ma'am?
So, hi there. Thank you. This has been a good debate. I have two different things to say. One is that we talk a lot about the 6-month prognosis. Nationally, 10 to 15% of patients, Medicare patients admitted to hospice or discharged alive, no longer having a 6-month prognosis. So that's a fairly large margin of error. The science and the art behind prognostication of 6 months is very, very difficult. So that's one of my comments, not actually a question. And the second is, I feel obligated to talk about the state of palliative care and hospice in the state of New York, as I represent hospice and palliative care providers across the state. And it is a little disturbing to me that we have less than half of the hospitals in the state of New York having palliative care providers. And in New York, we are 48th out of all of the other states in hospice utilization under Medicare, with Medicare statistics. So I think it's a misnomer to say that we have a flush hospice and palliative care program. So as we talk about legalizing aid and dying in New York State, then we really have to look at what the other alternatives are, and we need to spend much more attention in bringing more hospice and palliative care services to light.
I completely agree with all of your facts. We have a terrible underutilization of hospice in New York State. Prognostication is often wrong, but doctors should inform their patients so that patients can make an informed decision for him or herself as to whether or not he or she still wants to obtain the medication, just as the patient who might want to have life-sustaining treatment withdrawn can be told, well, you know, if you stay on this ventilator, you could live another 20 years. But the patient has a right to make that decision. And I'll also tell you that even though we have an underutilization of hospice in New York, there are lots of hospice medical directors who support medical aid and dying. I know of 8 of them across the state who, in fact, support medical aid and dying, either current or former medical directors of hospices. So hospices, even though people should be in hospice, and most who are going to be getting hospice will not want aid and dying because hospice really provides excellent care and services in general. There will be a small number of people whose suffering can't be controlled, and the medical directors of these hospices recognize that, and that is why they support medical aid and dying.
Just to add, though, on the hospice element, I fear for the ethos of the hospice movement if aid and dying is legalized. Because right now, my understanding is that hospice would not promote assisted suicide, but I think if it is legalized, then there is going to be an element of introduced into hospice that either encourages it or offers it or facilitates it. So I wonder for the, we all look to hospice as having a wonderful ethos of life-sustaining and life-affirming care. But I worry that if assisted suicide is legalized, that hospice will become corrupted by it and will become a facilitator.
Well, I know we could continue for another couple of hours. So to wrap this up, I would like to ask the panelists if they would like to make one brief final comment before I let you go. Edward?
No. Well, again, I think that the most important thing for us to understand is that we have to affirm everybody's life as it is. Life is an incredible gift to all of us. It is a beautiful thing. Even when it may have some difficulties, it is a beautiful thing. And I think as a society, if we start to recognize and continue to recognize, given what else is going on in our world, if we recognize that some lives are not worth living, that it's a very dangerous place to be, especially if one becomes weak or vulnerable or depressed. We should be more protective, we should be more affirming and not disaffirming of the way people live their lives.
Thank you, Edward. And I'm going to go back and forth. Peter, another brief comment, perhaps in song? We haven't heard a melody from you tonight.
The fear of a slippery slope should not deny people a fundamental right.
Thank you. Stephanie?
We live in a world that doesn't afford everyone the opportunity to live, particularly vulnerable populations. And we're now considering allowing vulnerable populations to die and talking about it as if it's a choice. It's not a choice when we only offer one option to the most vulnerable populations, and it is to get rid of us. And I say us because I'm part of that population that would very much like to stick around.
Thank you. David?
This issue is not about people with disabilities, but for those who may have a disability and are at the end of their lives, consider what Paul Spears said. He was a wheelchair user. He was a neuropsychologist, taught at MIT and Boston University. And what he said was this: I am better protected because we have laws which have all of these safeguards for medical aid in dying. What he said was that if I should ever be in a situation where I'm terminally ill, I would want the right to make that decision as someone who does have a disability. Maybe it wouldn't be the decision that 10 other people would make, but it would be my decision. I can protect myself. I don't need others to protect me. I can make my own decisions. That's essentially what Paul Spears said, a wheelchair user, because again, this is about human rights and about the individual's right to make a decision, whoever they are, in determining when their quality of life is diminished to such an extent that they can no longer live in, as in fact they are dying.
Thank you, David. And our honorable keynote speaker?
This is a fascinating discussion. When I was listening to everyone tonight, I thought, I should have come here before I wrote the opinion. They're all brilliant, they were all great, and you never stop learning in these things. And so I feel that as this gentleman asked a question here, I imagine this issue will be for us again, and I'll take this experience and incorporate that hopefully into whatever decision we have to make again on this issue. But I want to thank you for being invited. It's great.
And thank all the panelists and the judge. Great. Do you want to come up here? Let them know about the
Well, thank you so much again to all of our panelists and Judge Fahey and our wonderful moderator, Professor Bonventuri. And thank you everyone for coming out. We have a reception in the foyer downstairs. It's catered by Raganese, so it's really good. And we have a lot of food, so please come. Thanks.